we can illustrate by referring to some judgments how the European Court has succeeded to protect whistleblowers, to protect investigative journalists, to protect sources of journalists, also in areas which are normally considered very sensitive and very difficult to create transparency. The first example I would like to give is the example of Youth Initiative on Human Rights versus Serbia, a case decided by the European Court. The complaint was by this human rights organization in Serbia that they were refused access to documents that could give evidence of the fact that the Serbian intelligence agency was surveilling journalists and politicians, an activity which was to be considered illegal. The human rights organization in Serbia wanted to have access to criticize this way of behavior by the intelligence services, but these documents were refused. The request was repeated, but at all levels, after exhausting all national remedies, not creating any access to the documents, nothing else was left for the human rights organization in Serbia to appeal, to complain at the Strasbourg court. The Strasbourg court looked at the case, referred to some other case law and could see that also an NGO, just like media, play an important role in highlighting crucial issues for society. So this human rights organization wanted to have access to documents to substantiate, to give evidence of their discourse which was critical to the behavior of the intelligence services. They needed this documentation in order to have good arguments regarding their policy to improve the work of the intelligence services. And therefore, the European Court said that they indeed had a right of access. In other words, that the refusal at all levels by the Serbian authorities to share this information with an important NGO and hence with society, that this refusal was a violation of the right of freedom of expression and information, including the right to receive and have access to information. This was not only a very important judgment by the European Court, recognizing that also in the field of intelligence and security there is an accountability to share information with society. The court took also a very firm point of view, a very firm attitude. And in a very exceptional way, the court not only found a violation, but also ordered the Serbian government, the Serbian authorities, to release the documents. So a direct order from Strasbourg to a member state to execute immediately the judgment of the finding of a violation of Article 10. So this was a clear symbolic action also by the European Court to take this kind of issues serious and to execute and to implement this approach by the European Court. That is an example of access to information in a very sensitive area protected by the European Court of Human Rights. A second example is a case of whistleblowing, and that brings us to Romania, in the case of Bucur and Toma in Romania, where there was an officer working for several years in the Romanian intelligence services, becoming aware that the Romanian intelligence services were also surveilling some persons, were developing some activities which were outside their competences, or to formulate it stronger, which were blatantly against the law. He leaked information from within the Romanian intelligence services, to a journalist, to certain media, in order to bring this scandal under the public eye. Very fast, the intelligence service found out that Mr. Bukur had leaked his information to the media. He was dismissed from his job and other sanctions followed. After exhausting all national remedies, in which Mr. Bukur was the victim of an interference with his right to freedom of expression and act as a whistleblower, as he argued, he went to Strasbourg. And the Strasbourg court again found in this case a violation of Article 10 of the Convention, protecting the act of a whistleblower, giving information of crucial importance on how some public agencies are to behave in a more accountable, in a more democratic controlled way. So again, here in this case, the state of Romania, the government, was convicted for breach of the European Convention, and at the same time the court sent a signal to the other 46 member states to apply this kind of principles in protecting whistleblowers in areas where there is a crucial value for our societies to be informed about what is happening in some organizations, in some companies, when it is illegal, when it damages public goods or public values.